What is a Section 48 notice? Landlords of residential tenancies in England and Wales are required under Section 48 of the Landlord and Tenant Act 1987 to supply their tenants with an address in England and Wales, to which they can send notices and be certain that they will be received. Hi, I'm Felix from Blackstone Solicitors, and in this video we'll take a look at what a Section 48 notice is and how one is properly served. So, why do you need a Section 48 notice? When identifying each party to the lease, the landlord's address is usually included in the tenancy agreement. However, it is subject to change throughout time. Any claim by the landlord for rent, rent arrears, service charges, or administration charges is not enforceable by court action if the landlord fails to provide a legitimate address. Amounts that would have been due otherwise are only treated as becoming due when the landlord follows the law and gives proper notice, regardless of any earlier demand served. Section 48 prevents the landlord from demanding the recovery of any rent or service costs unless the proper notice is given serving a Section 48 notice. Any landlord must provide a tenant with an address in England and Wales where notices and actions can be served on the landlord. If this is not done, rent will not be payable until it is provided. It's important to realize that Section 48 does not make the tenant free from paying rent. So, if a landlord is in violation of the law, any outstanding rent will be owed in full as soon as he is in compliance. Furthermore, there is no specified means for delivering notice. As a result, while some people refer to a Section 48 notice as if it were a specific form that must be followed, this is not the case. It's not like a Section 8 or 21 notice, which must follow particular guidelines. This is an important point to remember. The tenant must be given information in writing to satisfy the Act. There is no specific manner in which it must be given other than in writing. Consequently, oral notice is not sufficient. It is not a requirement that notice specifically states that it is being given under Section 48 or that it states an address is being given which is suitable for service. So, a tenancy agreement containing the landlord's name and address, as well as a Section 21 notice containing the landlord's name and address, will suffice to satisfy the Act, on the basis that if the tenant has been clearly informed of the landlord's address, then that is clearly an appropriate place to serve notices. A letter from an agent certifying that the agent is a suitable person to serve notifications upon is also acceptable. As such, there is no precise style or format that must be followed. A statement in a letter specifying an acceptable address for notice service or referring to Section 48, as well as a notification from a landlord providing the landlord's name and address, would suffice. There is no requirement for a specific structure or format, and any assertion that it is clearly incorrect. In any case, this is a problem that can be readily resolved at any time by just providing the correct name and address. If you need legal help with a tenancy agreement, contact us at Blackstone Solicitors Limited. We have offices in Manchester and Central London and have clients across the country. If you found this video helpful, like it, share it and tell other people about it. Press the subscribe button below to keep informed about our latest videos. Goodbye and thanks for watching.